Welcome. I'm glad that we're starting adult ed again in the fall. I'm glad everybody's here. We're starting, this is session, this three-part class that we're offering we were going to do in the spring, and then everything happened, right? So happily, Steve and Jerry and Dana agreed to shift their calendars and talk to us now in September. So this series, as you guys probably already know from reading the eGram and Connect, is on ethics in practice. And so they're each going to be speaking from their own fields of experience and expertise. Dana is going to speak about leadership in the military and in government. Jerry is going to be talking about ethics in business. And Steve is here with us today. And he's going to talk about ethics in psychology, in particular forensic psychology. So let me tell you a little bit more about Steve. He's a psychologist, as I said. He grew up in Colorado, but he was enticed east by UNC for his graduate work. Came to St. Elizabeth's for his internship and has been here ever since. And at St. E's, though he started out in the clinical branch of things, the most interesting psychology was going on in the forensic division. So it's not because he watched so much CSI as a young kid, it didn't exist, that he thought forensic psychology would be super interesting. It's because that's where some of the most engaging psychology was going on at the time when he was in training. And so as a consequence, he spent the rest of his career focusing on that part of psychology. So Steve, I think that's enough introduction for you. If you want to get started and walk us through this, we would love it.
Anyway, as Jennifer said, and some of you may be aware, I'm a psychologist, and I actually am a psychologist that focuses predominantly on forensic psychology, which is really talking about the application of psychology to legal issues. And in my case, what it is predominantly, I see and work with adults, and I'm dealing with criminal matters, so I'm not dealing with civil issues. So I don't deal with things like custody or personal injury things that much at all. The pictures here, the fuzzy one at the top is John Howard Pavilion. As Jennifer kind of alluded to, I was at St. Elizabeth's, and for almost 10 years I was at John Howard Pavilion, which is the forensic inpatient part of St. Elizabeth's. I moved to teaching in doctoral programs, and but continue to do private practice in forensic psychology. So the middle picture there is the new St. Elizabeth's. It's a much prettier hospital that's much smaller. And then down there is DC jail, maybe not quite so pretty. But that's where I spend a lot of my time sort of seeing folks. And actually in this pandemic, I've been seeing them virtually there, which has been an interesting sort of shift and change. But I deal with issues around competency, risk assessments, and insanity. And that's what I'm going to kind of focus on. And when Jennifer was first talking about this kind of notion of thinking about ethics and practice and how we sort of think about what's ethical, what's moral, how we sort of look at those issues, I talked with her some about this whole notion of how we look at insanity, how it gets played out, and thought it in some ways was as we started looking at issues of responsibility, blame, guilt, and the kind of ethical questions that come from how we look at that it might be interesting. The other thing that was timely when we were first having this discussion was that the Supreme Court had just had arguments on a case called Kansas v. Kahler, which was trying to decide whether there was a constitutional right to an insanity defense. And they actually made their opinion came out in the spring. So if we had it at the time that it was scheduled, we would have been like predating their decision by like a week or two, which would have been perfect in timing, but it's fine. And we'll talk about the decision. I'm not happy with it, but hey, I'm not on the Supreme Court. Anyway, I actually put a little roadmap just to let you sort of know, like, where is he wandering to? So you have a sense of like where I'm wandering. So what I was going to do is I was going to talk a little bit about just the insanity defense in terms of like the prevalence of it, the rationale for it, and kind of just really run very quickly through kind of just the history and shift of how it's been defined. And then talk about what some of the implications are in terms of having one, in terms of how we look at current treatment of inmates. and then also spend some time talking about kind of how release is defined, which is also, I think, sort of interesting, particularly when we start to talk about issues around moral responsibility, and kind of open it up to sort of discussion stuff. So the first part I'm going to talk through relatively quickly, because I think probably the talk part is more interesting and questioning, and I'm curious in terms of different people's thoughts and ideas about things. First, let me just kind of do a kind of a quiz. Oh, I can't see the participant chat thing. Jennifer, you'll have to monitor chat. So either you can unmute yourself, or if you don't want to unmute yourself, that's fine. But just here's a kind of a question for people. How often do you think defendants, like in felony cases, raise the insanity defense? Do you think it's like a third of the time, 15%, 5, fewer? What do you think? How often is it used?
Not often at all.
Okay. What
But
about
I used to test. I'm a forensic scientist, so I used to testify in court. So
oh yeah,
that's not fair.
You're not fair. Go back to the mall where you're hanging out. And yeah, no, that's fine. And, others' thoughts? Well, all right, we'll go to the next question.
Type in an answer, like those people are doing.
I'm seeing answers from the chat, 5%, fewer.
Oh, what a learned group. And how often is it successful, do you think, when it is raised? 90% of the time, 50%, 30%, fewer? What's the chat saying, or people?
Let's see, the chat is saying fewer. Let's see, one person said 30%.
Okay. All right. You guys are so knowledgeable. So, and you're clearly the meeting house is not like the general public in terms of either your experience, your knowledge, or just your ability to guess accurately. One of those three. But it isn't used much. It's actually used less than 1% of the time. Again, it varies a little bit by state. It's not often successful. It's only successful 25% of the time that it's raised. And here's the other interesting thing. When it's raised, 70% of the time it's what's called stipulated. In other words, the prosecution agrees. They're like, hey, we're not going to have a trial. We're not going to contend it. We agree. This person meets the, so we're signing off on it. So it is interesting that it is rarely used, infrequently successful. And when it's successful, basically everyone in the court agrees, so no one's disputing it for most of the time. Also, people sometimes talk about like the insanity defense is like getting away with it, but the length of detention is similar to felony convictions, though the recidivism is much lower. And just in terms of to show you how you're exceptional is that most jurors believe it's abused. Most actually jurors also believe it's okay to punish the insane. And that studies have shown that people believe that it's actually raised more than like 40 times more often than it actually is. So it is interesting in terms of sort of people's sort of preconception of that insanity offense. Let me talk a little bit about sort of the kind of the rationale and reason of it, which kind of starts to get to some of this notion of how we look at punishment and responsibility. So, there are a number of reasons to, why do we punish people? Because it feels good. No, that's not, that's not the good reason to punish people. So, one idea is this kind of notion of just desserts, the notion that, if you do a crime, you should get punished, but you should get punished proportionately to what you did. The notion that, in the old days where if you stole a loaf of bread, you would get sent to Australia or hung, people would say, well, wait a minute, that doesn't seem fair. Okay, maybe you need to get punished for stealing your loaf of bread, or maybe you don't. You can argue in terms of issues of food stability, but that's another notion. But generally people say, okay, this makes sense. You make it proportional. Another notion in terms of it is deterrence, the idea that you punish people to deter them from a crime. It's like, oh, if I know that I was going to go to jail for 6 months, a year or something, I wouldn't have done that. If you know that you're going to, steal from a bank, but you're only going to get a weekend in jail, you might think, oh, well, that's not such a terrible, risk. That doesn't really deter you. So those two notions of punishment, and the idea of how it sort of impacts it, when you think about mental illness, doesn't sort of work, right? Like what is proportional if somebody doesn't understand or is confused about or has some sort of distorted belief about why they're doing what they're doing or why they need to do what they're doing? And how does deterrence work? I mean, if you believe that what you're doing is going to keep the world from collapsing and falling apart and destroying the universe, you need to have a pretty strong deterrence to keep you from doing that action if you morally feel like that's the thing you need to do. So when we start to talk about it, how do we treat folks who are mentally ill or who have a significant serious intellectual disability? The kind of common ways that we sort of look at crime and punishment don't sort of fit, and that's been there for a while. I mean, the other two kind of concepts I just want to sort of throw out there is this notion of mens rea and actus reus, and we'll come back to them. But the mens rea is this idea of, did you have the guilty intent? Were you doing a crime with some specific intent to do a crime? As opposed to that you didn't have the intent. And this sometimes gets raised with the issue of mental illness. And actus reus is, did you actually do the act? And that more rarely comes up, but sometimes with things like epilepsy, if you had an epileptic fit and in the process of that, you then while driving ran over somebody, while holding a gun ended up shooting somebody, the idea would be that you didn't actually do the quote unquote forbidden act. Sometimes gets raised with some issues in terms of things like sleepwalking or drug-induced sorts of alterations. We can talk more about that. But anyway, so let's talk about that. Like, I'm going to run really quickly through the history of just to kind of give you a sense of like how in a sense legal systems have talked about that the whole notion of insanity. Which has been raised actually early on. I mean, there's like early Hebrew and Babylonian writings about it. Aristotle talked about this whole notion of like, to what degree do you hold somebody criminally responsible if they're in some sort of altered state? In our legal tradition, one of the first cases that really sort of dealt with it is the Rex v. Arnold one, where Arnold, it was an individual who shot an English lord, claiming that the Lord had sent to his chamber different devils and imps at the night, so he couldn't sleep. And basically, what happened, the judge at the case gave the jury the instruction that to be found, in a sense, not criminally responsible, a man must be totally deprived of his understanding and memory so as not to know what he's doing, no more than an infant, a brute, or a wild beast. Which is a pretty high standard, but I mean, what you're talking about is a lack of complete understanding of what you were sort of doing. And then that's sometimes called the wild beast standard. So, but that was at least an early articulation of the notion of insanity. And the one that's probably most famous, and you may have heard of it, is the issue of McNaughten, or what we'll sometimes call it the McNaughten Rule. McNaughten was a Scottish woodworker. Nowadays, we would talk about him suffering from paranoid type of schizophrenia, but he had delusions about Robert Peel, the prime minister, and then attempted to assassinate him, but actually killed his secretary, Edward Drummond. A side note is that actually Drummond probably didn't die from McNaughton's assault, but actually probably died from his treatment. They treated him with leeches, and they removed so much blood via the leeches that modern historians sort of figure that that's actually what probably killed Drummond, was the treatment. So a word to the wise. But anyway, all of the doctors agreed that McNaughton suffered from a mental illness and from schizophrenia. And the McNaughten Rule came afterwards in terms of the judges of the Supreme Court, where they came up with what they consider a rule in terms of how to define and articulate what does it mean to be insane. And so it talks about a party was accused with laboring under such a defect of reason from disease of mind as not to know the nature and quality of the act, or whether the accused knew the difference between right or wrong in respect to the very act in which he is charged. This is often called the cognitive prong, And it's the idea of whether you know the nature and quality and whether you know the difference between right and wrong. That the nature and quality of an act actually rarely comes up. I mean, you'll hear like hypothetical examples, like somebody thought that they were, whatever, that they were, cutting the head off of a doll, and it really was a person. Well, in actual practice, people rarely, don't understand what they are doing per se. And so usually it's the issue of wrongfulness. And one sort of little side part about it is the issue of legal versus moral wrongfulness. And states vary on to what degree they sort of explicitly recognize the moral one. In the strictest fashion, the legal wrongfulness means, do you know that doing what you did is a wrong thing to do? Versus morally, do you feel that it is morally wrong to do? The picture up there is Andrea Yates, for those of you who may or may not recognize it. And if you may remember, in her case, she drowned her children. She suffered from severe depression, psychotic level depression, believed the end of the world was happening, and that her kids would end up in hell. And so the only way to save them was to kill them. And there really was no dispute about her mental illness or the beliefs that she held. But one of the issues at trial, there were a number that were there, but one of the issues was, to what degree would she be judged in terms of, did she know that it was wrong to kill somebody? Which is a very strict and very kind of rigid way of looking at the legal wrongfulness. Or did she morally believe that it was wrong? Which, of course, as I've described to you, she didn't. And actually, her first trial, she was convicted, and then it was brought back actually on a secondary notion. And there was an expert who basically had mistestified, and I won't go into the details of that, but it was a pretty egregious thing that he had done. And on that second one, the moral issue was much more clearly sort of to the forefront. And so she was found not guilty by reason of insanity. So that's the McNaughten Rule, which is called the cognitive one. And as I said, some states vary on that. The other rule is called the irresistible impulse. Sometimes called the volitional prong. You don't know the nature, quality of the act, or it was wrong, or unable because of the mental disease or defect to adhere to the right. Sometimes it's called the policeman at the elbow. Would you do the crime if there was a policeman right next to you? In other words, your mental illness so removed your ability to control your behavior. I had seen, when I was at St. Elizabeth, somebody who he was homeless and who had basically was residing on park benches right next to Superior Court. I always think of him as the perfect illustration of irresistible impulse. There's a church there, an Italian, I think, Catholic church that's there. He'd come in there, grabbed the baptismal, dropped it, broke it into pieces and chunks of marble, and started throwing it at a congregation during a service. He was arrested. Nobody was hurt. That's very good. But then he was released. And a short time later, then a police officer came up and saw him, and he was holding something. He was dropping it on a bench. And then they realized, oh, there's somebody lying on that bench. He was dropping actually it was like an old generator or something that he had, I guess, found. And again, they arrested him, and he was released. Which, again, you can talk about some problems in our system in terms of that. So the third time, and this is one that illustrates the irresistible impulse perfectly. Middle of the day, he's near the National Building Museum, and he sees somebody coming out of a building, and he realizes this is the woman who has kept him from his inheritance. He believed that Howard Hughes had actually given him his wealth, but that various people were keeping him from getting that wealth. And he was upset because this is the woman who had caused all the problems in his life. Now, if any of you know where the building museum is, you know that there's a memorial there. It's the police officer memorial. And guess who visits the police officer memorial? Police officers. So anyway, he grabbed a flag that was in the ground and starts charging at the woman. Like a lance. She thinks this is a robbery attempt. She screams, it throws her purse. Of course, this isn't a robbery. This is revenge. This is, he's had all these years of abuse. Luckily for her, as I said, this is the policeman memorial, there was large groups of policemen around there. And so they quickly tackled him and prevented, so she was not harmed at all. But this is a perfect example of the policeman at the elbow. I mean, the fact that there were a number of officers, some of them uniformed, did not deter him from doing what he felt he had to do, which was stemming from his mental illness. The ALI standard, the American Law Institute standard, really did capture both of this. And this was actually the standard that was used around the country, and it had both a cognitive and volitional prong. And, you know, basically talking about in terms of to what degree you either knew what you were doing, could appreciate the criminality of it, or you could conform your conduct. And what changed this is the standard around the country for really almost all jurisdictions was this event. And this was John Hinckley. After John Hinckley was found not guilty by reason of insanity, that a number of the federal standard got changed. That was the Insanity Defense Reform Act. And so what it did is it basically changed it to make it clear that the burden was on the defendant, raised the standard, just had the cognitive, it removed the volitional prong. But a lot of other states did other kinds of changes in terms of narrowing the insanity, including also eliminating it in a number of states. And so a question has been there in terms of, well, is there a constitutional right to insanity, or not? Even though it's been long recognized throughout the legal history. The Supreme Court has tended to dodge it. And so the closest it came, there's the changes, and there's John Hinckley. But the closest it came to it was in 2006, before this year, Clark v. Arizona, where Arizona had changed it and basically had made it very narrow in terms of the cognitive part. And so it was more of, did you know it was wrong? And in this case, Clark shot and killed a police officer. There was no dispute that Clark had paranoid schizophrenia. They had delusional beliefs. He believed that there were space aliens who were impersonating police officers, and that's what sort of led to his crime. But based on the Arizona law and the changes, he really could not present any evidence of his mental illness. The Supreme Court, in a relatively narrow kind of interpretation of it, said that's okay. He still could present what's called a mens rea defense, and so that was sufficient. And that leads us to the current case that came up.
Like
Oh, go ahead. I'm sorry.
You have an intent to do something, and it's cognizant.
Yes, and so in Clark, it was the idea of, here, I'll even go back up. Oh, there we go. That they eliminated the Nature and Quality Act, so that wasn't so much, but it was just in terms of the, did you know it was wrong? And it was a very narrowly defined of, did you know it was wrong to kill somebody, is basically how it got defined. And they were not allowed to present any mental disease evidence at trial. So he was convicted, Clark was.
No, this is a guy, Clark, who shot a police officer thinking that he was an alien.
Correct. And actually, he was very, very psychotic at the time. In fact, it took 2 years to get him to be competent to stand trial. So yeah, there was no dispute about his illness. But the Supreme Court kind of sidestepped it on that. And this is the case where they actually started to directly deal with it, which is the Kahler v. Kansas. They argued it in 2019, and the decision came out this spring. Kahler is not a great example of insanity, by the way. Kahler was married, quote unquote, happily married, whatever that means. His wife had an affair, so I would guess that's probably suggests maybe not quite as happily as he thinks it was. They then led to divorce. He became more abusive, suffered depression. There's arguments in terms of obsessive compulsive disorder, some personality disorders. not clearly psychotic. Anyway, he went to the wife was living with her mother, went to the grandmother's house, shot his wife, killed her, killed the grandmother, killed 2 daughters, did not kill the son, decided not to kill the son. Kansas was one of the states that had eliminated the insanity defense. And so the argument in terms of Kahler was to raise the insanity defense, and that by only being able to raise mens rea, that had the argument was that was a violation of the 8th and 14th Amendment. And so that's what the Supreme Court heard the last fall, and then decided this spring, or at least announced their decision this spring. Stephen Breyer gave a kind of a nice illustration of what does it mean when you say the difference between having an insanity defense versus just a mens rea one. Breyer's example was, if somebody kills a person thinking that they're a wolf, they don't have any mens rea. In other words, that's a mens rea defense. I did not realize what I would thought I was just killing a wolf, not an illegal act, at least not an illegal act in many states, versus you kill someone because a supernatural wolf has told you to, and you've been hearing communication from the supernatural wolf, and it has told you you need to kill that person. By 6-3 ruling, the Supreme Court has said states are not required to adopt an insanity defense. So the Supreme Court has finally ruled, but it has now said that states have the freedom to do whatever they want on that, including severely and significantly limiting it. So in Kansas, it is only mens rea. So only if you think you're killing a wolf can you, in a sense, use your mental illness as a defense. So let me talk about, so there's your brief history of insanity, and where we've done. So here's the thing that when we start to talk about kind of responsibility, morality, and things like that, there are 2 kind of issues and questions, or things that and I'm gonna, I gotta go past. One is this notion that's been talked about, the idea that by allowing an insanity defense, some people have argued by having that exception, we kind of justify treating everyone else the same. Here's the basic notion is, if we say that there are some people who are quote unquote insane, then we're saying everyone else was sane, that they in a sense took a reasonable, rational kind of action, maybe not reasonable, but a rational action, and they were in control of themselves and their thought process. And therefore we should be able to, all the things about the deterrence and just desserts, that we can sort of treat them in a similar fashion, which ignores a lot of the information in terms of, if you look at who do we lock up, we are locking up people with significant mental illness at a disproportionate rates. So there are 3 times as many people with serious and mental illness who are currently in jails and prison than in hospitals. And again, different surveys, different numbers, but things like over half of the inmates have mental health problems. It's more broadly defined than psychosis. But using a similar kind of standard, you only have 10%, the general population. When you talk about psychosis, again, there's variability on the studies. Some have shown things, talking about things like 10 to 15% of people in state prisons or in jails have serious mental illness. We're talking about schizophrenia, bipolar, major depression. And actually, when they've looked at it by gender, the rates for female are even higher. And so one of the kind of questions, and I'm going to sort of hold it until when we get to the kind of discussion part, is kind of like, what does that say about, in some ways, the argument in terms of the insanity, you can say, okay, we're not holding these people fully culpable of what they did because of the serious mental illness. But what does it say for all the people who don't meet it, particularly since, as I've just talked about, what you've seen is a sort of progression to narrowing the defense and even eliminating it in some cases. So that's one question. I'm going to put that on hold because I want to talk about a second aspect of it, which is kind of an interesting notion. how does a quote unquote insane person get out? How do they gain their release? And so the usual standard is something along the lines of no longer a danger to self or others due to their mental illness. And actually there was a Supreme Court case that was sort of very well known about it. A guy named Jones, Michael Jones, who got arrested in '75 for stealing a coat, was found not guilty by reason of insanity, but then could not gain his release because he nearly never regained his sanity. And went to the Supreme Court to say, well, look, if I'd just gotten convicted, I would have gone to jail, maybe gotten a few months, maybe gotten 6 months, but gotten out. And now I'm years into it. At the point that it went to the Supreme Court, he was already locked up 8 years. And actually, he spent many, many more years. He was at St. Elizabeth's. But what the Supreme Court said is, no. You committed a crime due to the mental illness. So the presumption is that you are going to be a danger, and that you're not actually being punished by being locked up, you're being treated. So that's the standard in terms of it, is that it's an indefinite sentence. And it doesn't matter how serious the crime was or not, even if it was just stealing a coat, until you are no longer a danger. Here's the interesting thing, and let me tell you about one case that I was involved in. So I was involved in it in two roles. One is I was involved in the assessing role. This is when I was at St. Elizabeth's. This is an individual who had done some very, very serious crimes. He had shot a number of people. Some of those people had died. He was suffering from schizophrenia. He believed, he was hearing voices. The voices were telling him that they would crush his heart unless he did it. There was a racial piece to also some of the crimes too. But there was no dispute. This is one of these stipulated cases. This did not go to trial. The U.S. Attorney's Office ultimately said, yes, we believe that he was insane. So he was found not guilty by reason of insanity. As it turned out, I ended up being his treating psychologist afterwards and saw him in therapy. And so we started to talk about, both his illness and his realization of it, but also on what he had done, because there was an aspect of it that he was basically kind of hunting people, to be blunt, when he was doing this. I mean, there's no question that he was being driven by the hallucinations and some of the delusional beliefs. But we started talking about it. And I asked him, he was very close to his sister. And I said, if the voices had told you to do this to your sister, would you have done it? And he said, no. I mean, I would have died first. I mean, I would have let them crush my heart. I mean, I would not have done this. And I said, part of the issue is you didn't care. You didn't feel anything to these people. His case was actually one that had gained some notoriety, so that the press actually had accounts of some of the victims who had survived, or some of the family members of the victims who had not. And so part of what we did over a period of a year is we spent time talking about the people who he had impacted. And he came to realize and to, I believe, feel like they no longer were, in a sense, objects that he was quote unquote hunting, but he started to really sort of feel for them. He's still locked up. He probably will never get out, but there was a remarkable transition where, even though he is legally not responsible, in fact, we talked about that. I said, yeah, you meet the insanity defense. But let me tell you, many people who had those kinds of voices wouldn't have done what you did. You felt morally okay about doing this. And so a lot of our therapy was really on the moral responsibility. He's been there for many, many years. I occasionally will see him. He still remembers me, and he will come up to me and talk to me. And I hear reports sometimes from different attorneys on both sides about what's happening. One of the things that was remarkable early on, there was a hearing, and one of the victims' family members wanted to testify. They actually didn't. It was not a hearing where they would be allowed to testify. His lawyer objected, the prosecutor agreed. He overruled his lawyer to allow the person to testify, even though it was actually against his best interest, but he felt that he owed that to them. Yeah, there was a remarkable transfiguration of how he, I think, sees and believes what he's done. He has spent time. One of the victims was blinded. He spent several weeks, going where he covered one of his eyes to try to sort of have some sense of what it's like for them to be going through the world, with some recognition that obviously that's not the same. But so the funny thing is, in his being found not legally responsible, he's actually acquired a sense of moral responsibility and some empathy for his victims. Interestingly, if he had been sent to prison, he would probably get out sooner, and there would be no attempt to actually have him feel any kind of sense of responsibility or blame or empathy. And so that's just my last slide, and kind of opening it up of like, what does it all mean? And so I guess, a couple of things, the two sort of, ideas that, I think sort of talk about this notion of ethics and morality and what do we mean when we start to think about our legal system and offenders. One is, what's the implication in terms of how we treat offenders, and particularly when we think of it as a dichotomous, you're either insane or you're sane, and where the reality is that the people who are locked up are usually have multiple issues. Rarely is there a person who is this clear sort of psychopath. In fact, actually, they're often the ones who spend the least amount of time locked up. And so, when we look at the rates of mental illness and of substance abuse problems, what does it say? What do we should do? I mean, one of the things that you see starting to happen a little bit is some issues like mental health and substance abuse courts, where there's some effort to try to divert folks into treatment, but they're limited. I mean, within DC, the mental health court exists, but there is only a limited number of offenses that you can have to get in there. And so I've been involved in cases where individuals, it's clear that the crime that they did is coming from their mental illness. It makes no sense to be going for insanity, but they're not eligible for mental health court because it's only the most minor of crimes that can come into that. And then the other one is, how does our current system lead to kind of moral personal responsibility for actions? Do we just lock people up and then let them out? I mean, there are some restorative justice initiatives that are out there. I had a student whose dissertation was sort of looking at that and surveying across the different jurisdictions. But one of the things that comes out, though, is that how limited they are used. And they aren't really, I mean, because it costs money, because people that are like, why should we be spending money doing this in the systems? And so it doesn't happen. So anyway, all right, that's me. That's the end of all my like talking. I wanted to sort of present that and to kind of get it to maybe start people thinking. And